Thank you. Thanks to everyone for attending this session. The topic of this session is the safety professional acting as an expert witness. So to do that, we're going to cover a lot of different issues and items as part of this 90-minute talk. What I'm going to focus on is the types of witnesses and the rules for expert witnesses. What does it mean to be an expert witness, and what rules do you need to know and follow in order to be an expert witness? I'm going to try to cut my talk to that limited portion, and then I'm going to turn it over to Chip to cover what are the different roles, rules, expectations that are going to be placed upon you if you decide to serve as an expert witness. What's the difference between consulting and expert witnesses? I'm going to touch on that as part of types of witnesses. Chip's going to discuss that in more detail as part of his talk. To be an expert, there's an expectation of your qualifications. He's going to explain what qualifications are expected of you. What's the difference between experience versus expertise in a subject matter? He's also going to talk you through the sequence of events as part of litigation. Discuss putting together your CV or your resume for purposes of working with attorneys, and the whole relationship of actually working with an attorney as your client. It's a very different relationship than many of you may have with the typical type of consulting clients. He's also going to talk to you briefly about depositions and then also what it takes to actually market yourself if you want to be an expert witness. So with that, I'm going to jump right into what are the types of witnesses that we deal with. The two main categories are essentially what we call lay witnesses and expert witnesses, and each of them is broken down again. Under lay witnesses, we have fact witnesses, people who actually have facts that are of relevance. So, for example, if you had developed the scaffold engineering plan, you would be a fact witness for that. But if you were the competent person who had actually reviewed it on the day of the collapse, you would be what we call a percipient witness. You perceived a fact. So they both fall into the lay witness category. They talk about something that's in their knowledge or in their perception, but it's limited to that perception. They can't expand beyond that. The category we're going to focus on today is the other category, which is expert witnesses. For expert witnesses, we break them down into two categories also, what we call consulting witnesses and what we call testifying witnesses. In many cases, you won't see a consulting witness or you don't know that a consulting witness exists. Also, smaller clients, plaintiffs, often don't have budgets to support multiple levels of witnesses. But Chip's going to talk in much greater detail about the benefits of both of them as to how they relate to testifying and how they relate to actually serving a client and the benefits of being either one of them. So the main difference is that for an expert witness, you don't actually have to perceive the item to be discussed. You can base it upon your knowledge, your expertise, your vast experience, and frankly, it doesn't even need to be based upon admissible evidence. I'm going to get more into that in a moment. So, why do we even care who's an expert? Well, I'm going to use here the federal rules as guidelines for this discussion, and realize that's just guidelines for the discussion. The federal rules have some of the more developed rules out there, and a lot of states adopt them. But your state or the jurisdiction you might be working in may be different. But essentially, for most times under the federal rules, a party has to disclose those people that will serve as witnesses. The other side of the litigation, of course, will have the right to question them, get depositions, obtain interrogatories, whatever it might be, but they have the right to know who they are prior to trial. And that's right in the federal rules of civil procedure, and most rules of civil procedure provide that. So as you see, it says, any witness that you're going to use at trial under Rule 702, 703, or 705, we're going to talk about those rules next, but 702 is the lay witnesses, is the expert witnesses, and 703 discusses how we're going to handle expert witnesses. So, testimony by experts. So here we're going to discuss the actual federal rule of evidence. What is an expert, and when do we want an expert? When can we have an expert? When do we need an expert? So I typically hate reading, but I do want to go through this because it tells you exactly those issues. So if scientific, technical, or other specialized knowledge will assist the trier of fact, So it's telling us the types of knowledge. So generally for safety type of work, you have some specialized knowledge that the vast majority of the population don't have. 12 people in a witness box are not going to understand fall protection and a positioning system versus an arrest system. They're not going to. So this would be a situation where specialized knowledge will assist the trier of fact. Assist the trier of fact. If it's a bench trial, you're trying to assist the judge. If it's a jury trial, you're trying to assist the jury. But being a good expert witness, you need to understand that. That is the type of person that you need to speak to and talk to and explain. So if you're helping the trier of fact to understand the evidence or to determine a fact and issue, a witness qualified as an expert by knowledge, skill, experience, training, or education. It's a huge, wide breadth of ways to become an expert. You don't need to have graduated high school, college, have a CSP. You might have 35 years experience. You may have gone through graduate school, master's, PhD, have all kinds of teaching experience and not have done it and still be an expert. We look at the totality of your knowledge, your experience, your skill, your training. We look at the totality of that. No one is dispositive of the rest. And that if you are an expert, then you are allowed to testify in the form of an opinion, or otherwise you need to base it, of course, upon facts and data. You just can't make it up because you feel that way. And it does need to be the product of reliable principles and methods. So you need to follow essentially what we can call the scientific method of deducing from facts and principles to your conclusion. And you have to apply them to the facts of the case. You can't simply dislike someone or dislike that fall protection system so you're going to testify against it. It actually has to be applied to the facts of the case. And if you're going to be an expert and you're listed under the disclosure as being an expert for the case, you're going to have to provide an expert report unless it's stipulated that you don't have to. Generally, it will be required. And if you're going to give that, there's going to be, the federal rules actually require specific items to be in that report. These are those items, and as I said before, you of course need to be familiar with your local laws, and whatever attorney you're working with should of course lead you through this. But there needs to be specific content, and most of these are fairly common. You need to present the opinions. The other side can't first hear your opinions when you're sitting on a witness stand or at a deposition. They should know what you're going to testify and what you're going to say. What data you're going to use to support them or that you use to formulate your opinions. If you're planning on using exhibits, pictures of samples, pictures of the accident scene, they need to have access to them. You need to provide your qualifications, including publications. Any other cases you've been involved in where you've been an expert, or even if it didn't go to trial, as most cases don't, if it was just a deposition. And you also need to tell them about what you're being paid for any work you may have done. You may have conducted a study as part of this case, or you may just be simply reviewing data and providing testimony. But you need to tell them what you are being paid and how you're being paid. Which leads us into formation of your opinions and how are you required to form your opinion. For you to form your opinion, you need to have a reasonable certainty in your opinion. And what does that mean? It's not a scientific certainty. We're not saying that you can't testify unless you're 99.97% sure that this is how it happened. That's not an expectation. You're not required to do that. But what you do have to do is it has to be more than mere speculation. You have to use the scientific method. You have to deduce from the facts of the case your opinion. So you need to have some sort of, as we say, reasonable certainty, some sort of basis for your opinion. But it doesn't have to be a scientific certainty. No one is going to say, are you 100% sure? Can it never have happened any other way? They may ask that as part of trying to beat down your opinion, but you're not required to have that in order to give your opinion. So earlier I said that when you make your opinion, it doesn't even have to be, as an expert, you actually get leniency. It doesn't even have to be based upon admissible facts. So, for example, if you were conducting an accident investigation, you would certainly look at witness statements. Well, that in testimony language is hearsay. You can't testify to what an observer saw on the day of the accident. They have to testify to it. But as a good practicing safety professional, I expect that you probably talked to those people and got their side of the story or what they saw, and that's all part of the basis of your opinion. Those are all not admissible facts that you're going to base your opinion on it, and as an expert, you're allowed to do that, which takes us to Federal Rule of Evidence 703, which basically just says that. It says the facts or data in the particular case upon which an expert bases an opinion may be those perceived by or made known to the expert at or before the hearing, if of a type reasonably relied upon by experts in a particular field informing opinions or inferences upon the subject. So we would expect that every diligent safety professional would get witness statements or would ask to see witness statements or would read the witness statement. It's all hearsay, but we would expect that the type of experts we're talking about, safety professional experts, would utilize that in forming an opinion or drawing an inference. And as I said, the facts or data need not be admissible in evidence in order for the opinion. The fact is that most of these facts can typically be gotten in other ways. There can be people who can testify to it, and if the person who was given the statement had died, most likely the testimony would come in any way through you. But the fact of the matter is, you need to do your job as a normal or good safety professional would do it and base your opinion upon that, and the courts recognize that. They're not going to say, oh, you can't use things like witness statements or things that you did not actually perceive and say it's hearsay and not be allowed to use it. So the elements that you're worried about to make sure that your testimony is going to be heard is your opinion, scientific, technical, or some form of specialized knowledge. If somebody needed you to testify that water on the floor is a slip hazard, that's in the recognition of every normal person. You wouldn't need a safety professional for that. That's not specialized knowledge, but that's the first hurdle. Assisting the trier of fact, you need to do that. And when we teach classes on being a good expert witness, this is one of the facts we really draw out, that you need to speak to their language and in their words, to talk to them so that a normal layperson can understand the details and specifics that you know well that are very difficult to translate to the average person on the street who has no knowledge of safety protection and management systems and those types of philosophies and issues that they're not familiar with or acquainted with. And last, have you based your facts upon those reasonably relied upon by experts? And I think that's typical of this industry, but it's something you need to think about when you have evidence that, if you decide that you're going to go to see a psychic to decide whether this fall protection system failed, that wouldn't be something that you could rely upon as part of your evidence. So why do we even care, and why do we spend this 15, 20 minutes discussing the rules of evidence? Because clearly we all know that it's not the most interesting subject. The fact of the matter is if you may have a great opinion, you may really be able to help a client, but if you can't get admitted as an expert, your testimony's gone. Numerous cases are decided on this fact and this fact alone. It's a litigation strategy. Attorneys don't need to know anything about the technical details. They just need to get the other side's expert thrown out, and they can win their case. It's a litigation strategy that you need to understand, so that you need to get your testimony in. The last thing I want to cover is, we talked about Rule 702 and 703, how we define an expert and what is an expert. There's two prevailing ways of thinking of experts out there. One is Fry, which is a very old case back from 1923, and it dealt with what was science at that point, which was actually a lie detector test, which was essentially a blood pressure cuff. And the Fry decision basically said that they will accept anything that has gained general acceptance in the